amendment is that this amendment is ultra-wise of the Constitution, and so that is the facts of the case, Your Lordship. And for Your Lordship's convenience, the Council will be dealing with issues number 1, 2, and 3, while the co-Council will be dealing with issues number 4 and 5. So the issues dealt by the Council are whether the petitioner's organization has locus standing to file the public interest litigation. Second, whether the impugned 130th Constitutional Amendment Act is in violation of the basic structure of Indica, and whether the impugned Constitutional Amendment Act constitutes an unreasonable restriction on fundamental rights of citizens warranting its annulment. The Lordships may permit, the Council would like to move into the issue arguments under issue 1. Much obliged, Your Lordship. Your Lordship, the Council is trying to prove in that these basic 4 assertions, these assertions are itself important in this case to prove that the renowned NGO has met the criteria for locus standi. It's humbly submitted before the Honorable Supreme Court of India that the renowned NGO establishes its locus standi by espousing legitimate interest on good governance. Your Lordship, there is also relaxation of locus standi and bona fide public interest in the writ petition, and in a plethora of cases from S.P. Gupta, from Vinir Narayan, and also satisfying the prerequisites in Jandadar versus H.S. Chowdhury, that is, the petitioner should have sufficient interest, that should not be a politically motivated, that should not be a frivolous appeal, and such a bill shall not be entertained. But in this case, there is a presumption of public harm, and also these interests should be sufficient interest, should be bona fide, should be pro bono publico, and that is being that are the requisites, and that has been met. The criteria has been met. Your Lordship, also in Fertilizer Corporation, the Council is placing claims in Fertilizer Corporation, Kanga Union versus Union of India, that the relaxed rule of locus standi for social justice, the prerequisites to establish the standing law to challenge the impugned 130th Constitutional Amendment has been met, and also to establish the NGO's bona fide interest, and also there is a Bill of Public Interest Foundation, Your Lordship. In that case, additional disqualification ground beyond the existing law, that is the RT Act, that shall not be added. That was cited in Bill of Public Interest Foundation, Union of India 2019, SEC 123. A bill affirmed for clean administration. Lordship, that is to be very effective. A bill affirmed for clean administration, good governance, to act only in public interest, and there is no political motivated. And also here, Your Lordship, another assertion is that the response council might assert that here there is no bar on reappointment clause, but that is considered to be only as a saving clause, Your Lordship, because the word nothing in the no bar on reappointment clause, that is also mentioned in the moot proposition, contains the word temporary. I assert, Your Lordship, that does not contain the word temporary. So here temporary removal, the removal is substitute for disqualification also, Your Lordship, because in the Bill for Public Interest Foundation, the moot proposition, as Your Lordship, the Council had already stated that there is no word temporary, and here it is similar to the language that is being used, that the shall cease to hold office is similar to the language as used in MP disqualification, MP-MLA disqualification, in shall be disqualified under Article 102 clause E, subclause E, and Article 191 subclause E, where shall be disqualified. So here the similar language is being used, Your Lordship. Also, the reappointment, as they have cited, the reappointment is a political discretion. The reappointment is a political discretion, not guaranteed discretion. So that may not be there. There is a word shall be eligible, Your Lordship, in the no bar reappointment. Shall be eligible. That's not may be eligible. So that should not be misconstrued, Your Lordship, with the words shall and may. And Your Lordship, in Quixote Holohan, in the case, parliamentary democracy case, disqualification is meant the loss of status opportunity, the loss of ministerial statute. Here there is a loss of ministerial status, the loss of disqualification by, so that is a disqualification by another name, Your Lordship. So here how the disqualification is happening, because, and what is the effect of the disqualification? Here the prerogative power to select the cabinet is being lost, and also the related to elements, substances and elements, and all the ministerial status is being lost, Your Lordship, because he is also a citizen, and that is fundamental rights also, Your Lordship. And here, Your Lordship, The council underscores the ultra-wise argument that is mentioned in the proposition ultra-wise argument, that is the 113 Amendment Act being unconstitutional as it potentially undermines the fundamental rights in Article 14, 19 and 21 of the Constitution of India, and also it is skewing the balance of democratic accountability and also executive discretion as cited in Rajnari. And also there is a public harm. Here, how public harm is caused, Your Lordship? Because there is a constitutional backup. Even when the PM or Prime Minister is such a constitutional functionary, and there is a special rule for PM and CML. So when they are being removed, so what happens is that such people who are they are being representatives of people. So when this PM is removed, so that is the quality of the governance, and also in such a way harm is caused to the public, Your Lordship. That is what here meant by the public harm is caused here with the 130 Amendment Act. Also, Your Lordship, the Council underscores that diverging from the RPA 1951, undue influences on the executive via the amendment. Even if there is no bar on reappointment, it triggers detention, ban conviction for removal. Writ petition on pro bono publico entertained by Supreme Court in Manoj Narula versus Union of India. And also, there is violation of natural justice principles under Article 14 and 21. It is violating audio alter partem and nemo juris in causa sua. Why? Because in Article 14, there is right of fair hearing, and also in 21 there is due process. Due process, one that should be reasonable, and that should not be arbitrary. The procedure must be reasonable here, Your Lordship. Because in this case there is no fair trial right, and procedure safeguards as cited in Amresh Kumar versus State of Bihar, that is not being followed here. Also, Your Lordship, Article 14, as Justice P. Makhawati has said, Article 14 is like a ruling omnipresence, acting as a bulwark against the arbitrary state action. Because Article 14 is providing for equality before law and equal protection of law. If in this case itself, there is an arbitrariness, Your Lordship, because if MP and MLA is giving a separate status, and it is cited that their MP MLA causes were not being disqualified, only them means